practice law, ma'am.
represent yourself or to follow the rules.
To practice law, you don't need to be a part of the bar association. Sorry. I already looked that up. Unless Mr. Lou Dang can show me a license, and I'm not talking about a bar license as well. I would dearly appreciate that as well. But yes, I rather represent myself.
Every time you appear in front of me representing yourself, I'm going to advise you again that it's a bad idea. I'm going to advise you again that you'll be held to the same standard as an attorney. And I'm required to do that. If it becomes a problem for you that I advise you that you'd be better served by having an attorney, then we're not going to get along very well, sir. I'm doing what I am required to do.
Right at this moment, the judge makes it clear that this isn't a gray area decision. The motions have already been reviewed multiple times, meaning the court has given full consideration before ruling. When a judge says there is no support for a motion, that's critical. It means the argument doesn't meet even the minimum legal threshold required to move forward. This isn't about disagreement. It's about the absence of valid legal grounding.
Representing himself, and as this is the start of a new proceeding, the people just ask that the defendant be advised of his rights to representation.
I'm advised on my rights to representation right now. I'm waiting for the subpoena to come back. So I'm asking the court for a adjournment until the 31st or a little bit after the 31st of May, considering the subpoena has not came back and nobody has not contacted me since I put the subpoena in. If y'all need a reference of basically when the subpoena was sent out, that would be I can send that to you. And then also, as far as the original witness is not on the witness list, the accuser, quote unquote. And then also, Your Honor, I was supposed to ask for a motion for the case in whole with the videotapes and the transcripts, which still has not been sent out to me. So I'm also waiting for that as well, Your Honor.
Mr. Cunningham, it's generally considered to be a very bad idea to represent yourself. I want to advise you that if you do choose to represent yourself, that you're held to the same standards as an attorney. And as you know, attorneys go to school for years to learn how to do what they do. I won't be able to help you to
practice law, ma'am.
Represent yourself or to follow the rules.
To practice law, you don't need to be a part of the bar association. Sorry. I already looked that up. Unless Mr. Lou Dang can show me a license, and I'm not talking about a bar license as well. I would dearly appreciate that as well. But yes, I rather represent myself. Okay. If you want to show me a license,
what kind of license are you?
Actually, I'm talking about the practice law, ma'am. I'm talking about the practice law. You don't have to have a license to practice law. I mean, this is not the first time I've been in front of you.
I know that, sir. You said that you wanted to see a copy of Mr. Danner's license.
Okay. Well, you just kind of. I mean, I'm not taking it as a threat or anything, but you stated it because he went to law school or whatever. That basically, I still don't know my rights, man. So one of my rights I'm asking is basically, yes, ma'am.
I'm required by law to advise you that it's a bad idea for you to represent yourself. I'm not doing it to
so is that
threaten you or intimidate you or scare you or anything else. I'm doing it because I'm required to.
Well, ma'am, I'm gonna ask this question then, ma'am. Is that advisement privately or commercially, ma'am? Is that advisement privately or commercially, ma'am? Is that advisement privately or commercially? Are you advising me commercially or privately? You just stated it, advising.
I'm advising you on the record.
Basically, an attorney.
I'm advising you on the record.
So would that be privately? Would that be commercially, ma'am?
It's neither. It's on the record.
How is it neither on the record when basically it's a you're not my attorney, so how can you advise me to do anything?
There are lots of things.
It's a question, ma'am. It's a question, ma'am. I'm just asking, how can you advise me to do anything unless you're a representative, unless you some type of representative, have some type of contract with the Cunningham party? Let me know, ma'am. Unless other than that, you're an arbitrator.
Mr.
Sorry.
Cunningham, every time that you appear in front of me when you're representing yourself, I'm going to give you the same advice, which is that you would be better served by having an attorney. I have to
Such
do
as
that.
the last
I
three
require.
judges, ma'am.
Excuse me, sir.
Go ahead,
Sir,
ma'am.
give me a minute to talk. Every time you appear in front of me representing yourself, I'm going to advise you again that it's a bad idea. I'm going to advise you again that you'll be held to the same standard as an attorney. And I'm required to do that. If it becomes a problem for you that I advise you that you'd be better served by having an attorney, then we're not going to get along very well, sir. I'm doing what I am required to do by law, which is to advise you on the record that you would be better served by having an attorney. And I'm telling you right now, I'm going to do it every time that you appear.
To get along, first of all, to get along and be in basically correct court proceedings and facts will be two different things, man. So to get along,
I didn't ask you anything, sir.
It sounded like a threat. Excuse me.
I did not ask you any
I just listened to what you had to say, man. I'm cutting you off. I just went through
Mr.
this with Ms. Perry, man. I was only stating my claim, man. I thought it was my turn to talk. If it's not my turn to talk, just let me know. I thought it was my turn to talk. If it's not, just let me know. But I thought it was my turn to talk. You just interrupted me.
What do you want to say to me, sir?
I just said what I was saying. I was trying to get adjournment until May 31st to basically get the information back from the subpoenas. And I'm actually basically Lou Dang, the attorney, to actually have the original witness, Calvin Kleinoff, on his witness list, man. That's all I'm asking. Other than that, I'm not asking anything else.
Your Honor,
Yes.
two things. First, if Mr. Cunningham would like an adjournment of this matter, I have no objection to Mr. Cunningham receiving an adjournment of this matter whatsoever. Secondly, the people are under no obligation whatsoever unless this matter is set for trial to produce any witness unless there is an evidentiary hearing in which there is a motion that is filed for an evidentiary hearing requesting the admission of an individual party who will be considered a res gestae witness to this matter. As there has been no articulation as such, and as Magistrate Garwood is not a party to the case, and also since Officer Kavanaugh, I believe in this case, would only be the officer who swore out the information, or in this case, as a complaint. In this case, that Mr. Cunningham, would you mind 1 second, sir? Would you mind 1 second? Thank you, sir.
Here you can see a recurring issue beginning to surface: communication breakdown. The judge openly states difficulty in understanding the defendant's arguments not just today but across multiple hearings. In legal proceedings, clarity is everything. If the court cannot clearly follow your argument, it becomes nearly impossible to grant any relief, no matter how strongly you believe in your position.
So, Your Honor, if Mr. Cunningham wants a trial to be able to exercise the court's authority of subpoena, then he can request a trial date and then try to have that occur. Or he can file the proper motion, as I am in receipt of a motion that is not the proper motion to be filed, nor is the relief that he is seeking such relief that this court would have the authority to grant. So it is my understanding that even if he wanted the adjournment or whatever subpoenas to go out or anything of that nature, that would be a non-starter, as that is not what would occur, as none of this was properly done according to the court rules or case law. So, but if he does want a trial, or if he wants, he can request a trial, and then he would be able to subpoena witnesses to be there to testify at a trial, as the court would fully advise him of that right. Beyond that, Your Honor, I am not in receipt of any intelligible motion in which he has stated any kind of claim in which this court could grant any relief.
Okay, we'll adjourn to May 31.
Excuse me, ma'am. I wasn't done talking, ma'am. If you look at first the document A1 basically sent to the Cunningham party, what was it? October 26, 2020. Basically, you look at A1 evidence. The states on there, Ryan Kavanaugh. He's not an officer. It just states original witness. Now, the original witness, basically, what we haven't had an motion for is basically for the head of the case. I can't think of his name. Matthews. That basically, quote unquote, they tried to amend in him to be the original witness, when basically the original witness was actually Ryan Kavanaugh, who basically is not a complaining officer, is not a officer. He was a regular civilian on the road that basically they tried to put in after the fact that basically I was not supposed to be on U of M territory. And then they searched my property. And then from there, they tried to add in Mr. Matthews as the original witness, when basically he cannot be the original witness if he's in charge of the case. That's kind of like a contradiction. And then at the same point in time, he did not sign up under penalty of perjury as well. So, I mean, I'm confused here, man, at this point in time. But I will take the adjournment to May 30, a little bit after May 31st, to find out if I can get the rest of my subpoena to go further or more than that. So if we can go to subpoena 31st, from there, my motion for a subpoena from there, I would gladly enlighten you about this case.
All right, were you asking for May 31st or another date?
I was asking just a little bit after May 31st would be much appealing over on my side, ma'am.
June 7th, is that all right?
Yes, ma'am. That'd definitely be okay.
All right,
what time would that
June
be, ma'am?
7th. 1:30.
Thank you.
You're welcome.
Recalling number 19 and 20, People versus Don Lee.
I'm fine. How are you? All right, Mr. Weems, are you wishing to continue to represent yourself?
Yes, ma'am.
And you understand that that most folks would say that's a terrible idea and that you'll do much better with an attorney?
Yes, ma'am.
Do you understand that if you represent yourself, you still need to comply with all the court rules and the law, and that you're not given a break just because you have not, because you don't have a law license?
Yes, ma'am.
All right, we're scheduled for a pretrial today. Mr. Weems, were you wishing to go to trial?
Actually, I don't know. Can I go on a breakout with, I guess it's a prosecutor or whoever I need to be talking to?
If you want to talk with him, then I will give you an adjournment and let you talk with him another time, but I need him to.
This is one of the most important warnings any judge can give. Representing yourself isn't just a right, it's a serious risk. The judge is emphasizing that self-representation means playing by the exact same rules as a trained attorney. There are no shortcuts, no leniency, and no assistance from the bench. This warning isn't personal, it's a legal safeguard, and ignoring it often leads to exactly what we're starting to see unfold.
You're on the docket.
Yes, Your Honor, I have no problem with an adjournment in this matter. The people did communicate an offer the last time that we were on the docket, and that offer still stands as pleading to count one, dismissing the remainder with a probationary sentence agreement. If the court would allow, I can give Mr. Weems my contact information so he can call me if he has anything that he would like to discuss.
Mr. Weems, you need to remain on video, please. Did you hear what Mr. Danner said?
Yes, ma'am.
Okay, and would you like his contact information so you can speak with him?
Yes, ma'am.
Go ahead, Mr.
Right.
Danner.
Okay, so the line to reach me here is, and my name is Lou Danner, so when you call, you just ask for Lou Danner. The number here is 734-222-6620. That is a way to reach me by phone. If you would like to email me at the prosecutor's office, it is my last name, Danner. So that's DANNERL, as in Lou, at washtenaw.org. You can feel free to email me there or to call the office line, and I will be more than happy to discuss this matter with you And please be advised to not discuss any actual factual basis of the case, as I do not represent you, and I want to make sure you protect your constitutional interests and not say things to me that may be used against you later.
Yeah, I know who you are.
Mr. Weems, we tried to mail your birth certificate back to you and it came back as undeliverable. Is there another address that we could send it to?
Yep. Yes, ma'am.
All right, what is that?
No, Ypsilanti, Michigan. Sorry.
48197 or 98?
98, if I'm not mistaken.
Okay, very good. Thank you, Mr. Weems. We'll adjourn your matter to next week, to June 7. That'll be at 1:30, okay?
Mom's birthday. All right. Love you. Thank you.
Your Honor, is that the date that I just want to make sure there's enough time for Mr. Wayne to actually reach out to me and contact me?
Yeah,
I know, does the 7th work for you to be able to reach out to me and discuss this case before that date? All right,
yes, sir.
he's nodding. Okay, thank you, sir.
Okay. You're all set, Mr. Weems.
All right, you guys have a nice one. Thank you.
Thank you, too.
Yeah.
Number 15 on the docket, People versus Bobby Cunningham, 22147 FH.
Lieutenant for the people.
How's Cunningham here?
Mr. Cunningham, do you still wish to represent yourself?
Yes, remain as always, which basically I put in documentation sent to the court. May have you reviewed or made a decision from there. Go ahead, man.
Mr. Cunningham, what I have from you was from April, and it appeared to be an attempt to write a subpoena.
Yes,
And
madam.
I'm sorry?
I say yes.
Okay.
Subpoena.
I'm not going to sign that subpoena. First of all, it's not in the right format. And second of all, it's directed to people who are not subject to subpoena, court officers.
All right. Well, excuse me. That's only one of them. If I may, excuse me, quote unquote, put my words on top of your words. One of them, that's only one of them. The second one is actually showing, which I had wrote the subpoena for, stating when I had got identification within the jurisdiction. Now, two, the jurisdiction that I came from before I came here is not the same, madam. Sorry. At the same point in time, I have not got no correspondence with the subpoenas that I have put out, what I have put in the workers myself, and also its contract to solidify these subpoenas to the necessary people that it's supposed to go to. Now, from there, I'm talking to you, which basically pre-trial, which is at this point in time, if you want to make a decision with or with not, I'm putting it out hopefully to the end of July, if possible. Somewhere around 23, 25 days of the month of Roman calendar date 2022 July. So from there, from basically the subpoena that basically I'm trying to get to, which is supposed to be on the witness list, which is on the also, excuse me, I might be slurring my speech a little bit. Simple fact of the matter is I might be a little intimidated by basically who you may have associated with Puerto Rico Act, which is you as well, which has to do with housing and throughout this jurisdiction of the Washtenaw County. Now, excuse me. If you want to look at, which is basically supposed to be on their witness list, is basically the, motion for Bradley versus United States, which basically comes to the identification of what's jurisdictional act, what has to go by every constitutional state, basically including the United States, 10 mile excuse me, 10 mile additional law. I had a basic contract with a passport. Let's say it's from there. Now, what they sent me is basically within we can say go back to A1. Now, if we go back to A1, as far as the motion and also the other motion that I put forth before me talking to you. Now, A1, as far as in the as far as the evidence, name and address, not correct. Now, the name and address is not correct, which basically, to me, has not been in any type of reference to why this is not correct. Now, the witness states, Ryan Kavanaugh. Now, Ryan Kavanaugh is not on the witness list, is which basically I've been asking, and which basically, as far as the transcripts and the videotapes, you have not presented, or the attorneys, I just had a little hiccup because I'm down on battery, So they have not supplied me with the transcripts or the videotapes. It's supplied basically why they're stating that some of this documentation that they sent me is not agreeing to what they have already affiliated. Now, they tried to, move the primary witness. Now, but my primary witness, what I just stated, is Ryan Kavanaugh. That's not on the witness list.
Okay, so Mr. Cunningham, I'm gonna stop you, Mr. Cunningham.
Yes, ma'am.
If there is a motion,
yes, ma'am.
Excuse me?
I'm asking to supply this information or bid this case. Simple.
If you're gonna
They
make
have not.
Cunningham, it needs to be in writing. And the
It's
only
already in
mo-
writing, ma'am.
The
Whether
only-
excuse me, I don't mean to interrupt, but whether Lou Sedan have justified and read through the motions and documents that's submitted, that's not on me, ma'am. I'm asking at this point in time, you subtract or dab it this case, or we go from there. Which basically right now is only a motion, which basically, it will be under the RICO Act. Simple fact is you and him have ties to, such as the housing association. I'm just making a statement here. Simple fact of the matter is housing association, Washtenaw Association of a degree of basically to supply law or put knowledge of law to. It's kind of a little bit Greek, probably a little ahead of some of the people, but at the end of the day, I'm just asking, he doesn't have the supply witness, basically Ryan Kavanaugh, on the document as a witness. If he doesn't have him on the witness, it's basically what they sent me to October 27th, 2020. Basically, I'm asking for this case to be dismissed, man. That's simple, cut, dry to what it is. Anything over there? I'm listening and understanding. Excuse me.
At this point, the defendant begins shifting into complex questioning that sounds structured but lacks legal relevance. Asking whether advice is private or commercial doesn't align with courtroom procedure. The judge stays composed and grounded in the law, reinforcing that everything happening is on the record. This moment highlights a key disconnect between perceived legal logic and actual courtroom standards.